Good afternoon. My name is Sloan Lambert, and I'm one of our attorneys here at Melone, Hatley, PC. Today, we're going to be talking about the difference between a guardianship and a power of attorney. Both terms that you've probably heard of and are fairly similar, but when it comes down to how they're actually interpreted and how you obtain these things, they're quite different. First and foremost, a power of attorney is a document that you can use in many different ways. It can be for money, it can be for healthcare, it can be for signing for somebody. But a power of attorney has a very distinct difference from a guardianship. And that is the fact that the person creating the power of attorney, the principal, the one who's actually signing over the right to do something, still has capacity. If you have capacity to make a contract, that means that you understand what you're doing, why you're doing it, and what power you're effectively giving the agent, who's the person who's able to do that thing for you. If you are still of sound mind, if you're still capacitated, then you're able to create a power of attorney in the form of a contract. Again, that contract can be anything from being able to sign over your rights for a house, being able to allow someone to access your bank account, something of that nature. But the biggest difference is the fact that the principal is able to understand what's going on and can actually have the capacity to create that contract. Very differently is a guardianship. A guardianship is a situation where someone has actually officially lost that capacity. They are officially incapacitated. That means that they either don't understand what's going on or they're not able to effectively create a contract for one of those reasons. They effectively operate the same way, where an agent is still standing in place of someone, but instead of them being referred to as an agent, they're a guardian. And typically that guardian is court appointed. It's someone that the court determines as a proper person to stand in place of the ward or the person who's being taken care of in that regard, the person who's incapacitated. Effectively, you can do the same things. You can still manage the finances, you can still sign on their behalf and things of that nature, but it wasn't necessarily the person's choice to allow that guardianship to take place. That is one of the vast differences between a power of attorney, where the principal can decide who they want to take over, versus a guardianship, where the person no longer has capacity to do so, and therefore they don't make that ultimate decision, the court does. If you would like for someone to ultimately be able to take care of your affairs, take over for you in some capacity, whether it be making medical decisions for you, making financial decisions for you, if you are of sound mind and you're able to create a contract, then that's something that I would encourage you to get ahead of now before something happens where you might become incapacitated and are no longer able to make those decisions for yourself. Every case is vastly different. You might not be aware if you have capacity to create a contract or not. You might not know if someone that you're wanting to create one of these powers of attorney for has that capacity either. And so call us at Melone Hatley PC, because your case is your own. And every single case is so vastly different that you might need an attorney to sit down with you, explain what's going on, explain what the court might view this as, and be able to actually tell you how to do it effectively. Here at Melone Hatley PC, we are your partner in divorce and estate planning and would be honored to walk alongside you in whatever you're going through.